Hey, what's up, Illinois Divorce TV? I'm attorney in Chicago, Bobby Buchanan. In today's video, we are talking about what is hearsay evidence. Hearsay evidence is a term that you hear a lot in pop culture, on TV, when you're at the bar talking about your case or the latest case in the news. Hearsay, conjecture, circumstantial evidence, these are the common terms that we throw out there. But what does hearsay actually mean, and how can it affect your divorce or custody case? Well, hearsay has a very specific definition. It's an out-of-court statement made for the truth of the matter asserted. So when you are in court, you're testifying, and you can testify to anything you want in court as long as it's relevant and you have personal knowledge of it. So if it's something that you saw or experienced with your senses, then you're going to be able to testify to it, and there's not going to be any hearsay issues. Hearsay becomes an issue when you're talking about what you said outside of court or what somebody else said to you. So a very typical example of hearsay evidence might be something that your child said to you out of court. Let's say that in a difficult example or troubling example, they said to you, mommy or daddy, whatever the case may be, hit me. That is hearsay evidence. If you're testifying to the judge that little Timmy last Tuesday said to you, mommy hit me with a belt and it hurt, that is hearsay, and it's not going to be let in for the truth of the matter asserted. It's not going to be let in. What does truth of the matter asserted mean? It's not going to be let into evidence for proving that mommy actually did that. Now, it could be let in under under an exception to the hearsay rule. There are 10, 15 possibly applicable exceptions. So, for example, excited utterance is an exception to the hearsay rule, meaning if the person said this thing while they were, because of excitement from the event itself, then that would be an exception to the hearsay rule. And the reason that it's an exception is because the courts have decided over years and years, these rules are as old as this country is, that those types of statements are more inherently reliable. We don't usually lie in the midst of a traumatizing event or an event that is evoking some sort of statement from us. So there's a bunch of different exceptions. So just because it is an out-of-court statement, just because it is made for the truth of the matter asserted, doesn't mean you're totally locked out from testifying about it. The other aspect of hearsay, especially in custody court, divorce court, when there is children involved, or when it's just a pure custody case, it is known for having relatively loose rules of evidence. So a statement that might not fly in criminal court or a lawsuit, a personal injury lawsuit or something like that, you might be able to get it in a divorce or custody case, because judges in these types of cases would rather hear more than less. And it's going to be your attorney's job, if a statement does get in that maybe you didn't want to get in, to make the argument to the judge, this is hearsay, it shouldn't be let in. And even if you do let this into evidence, you shouldn't give it as much weight as you would a statement from a witness who is actually in front of you testifying about what they experienced personally. I hope that clarifies some things for you on hearsay. If you have any comments, let me know in the comments, questions, anything like that. Want to continue the conversation, let me know down below. Don't forget to hit the subscribe or follow button if you want to get these videos which come out on a daily basis. I'll talk to you soon.